The morning it happened, the garden was still quiet. Raised beds full of collard greens and tomatoes. A mural on the back wall, painted by neighborhood children 30 years ago, still bright. A hand-lettered sign near the gate that read, "Established 1987. This land belongs to its people." By 8 o'clock that morning, it was rubble. A developer named Callum had sent in a crew overnight. No notice to the neighborhood, no hearing. Just machinery, darkness, and by sunrise, a press conference where he called the land underutilized and announced plans for a mixed-use development he said would revitalize the community. He had a permit. He had a plan. He had cameras and a podium and a prepared statement. What he did not have, what his entire legal team had somehow failed to find, was the name of the woman who actually held title to that land. And she had already been on the phone for 2 hours. To understand what Callum destroyed that night, you have to go back to 1987. The neighborhood was called Dunmore Heights. It sat in the eastern quarter of a mid-sized American city, the kind of neighborhood that had been systematically starved of investment for 40 years while the city built highways through it, rezoned its commercial blocks, and watched its grocery stores close one by one until the nearest fresh produce was a 40-minute bus ride away. The vacant lot at the corner of Clement Avenue and 14th Street had been sitting empty since 1971, when the city condemned a row of houses to make room for a highway expansion that was ultimately canceled. The houses came down. The highway never came. And for 16 years that corner sat, weeds and broken glass and a chain-link fence that nobody fixed. In 1987, a coalition of Dunmore Heights residents decided they were done waiting for the city to do something with it. They petitioned, they organized, they raised money through church collections and bake sales and a neighborhood association that had been meeting in the basement of Greater Zion Baptist Church for a decade. And then, critically, they did something that would matter enormously 37 years later. They didn't just lease the land. They didn't just plant on it informally and hope for the best. They established a community land trust. A community land trust is a specific legal structure, a nonprofit entity that holds title to land permanently, separating ownership of the land from ownership of whatever sits on it. The land stays in the trust. It cannot be sold without the trust's consent. It cannot be seized by a developer who buys an adjacent parcel. It cannot be claimed through a standard city permit process. The Dunmore Heights Community Land Trust was incorporated in the state on March 14, 1987. Its founding chair was a 37-year-old civil rights attorney named Josephine Mercer, who had spent the previous decade filing fair housing cases across the state, and who understood, with the precision of someone who had seen every variation of this story before, that informal community claims to land had a way of evaporating the moment someone with money decided they wanted the ground beneath them. She made sure this one wouldn't. Most people in Dunmore Heights knew Josephine Mercer the way you know a landmark. She had been there so long and so quietly present that she had become part of the neighborhood's architecture. She had grown up 4 blocks from the garden. Her mother had been one of the original petitioners in 1987. Josephine had done the legal work, the incorporation filings, the land trust bylaws, the title transfer from the city, the covenant language that would bind every future transaction. And then she had stayed, not as a figurehead, as the chair of the board, a position she had held, without interruption, for 37 years. In the years between 1987 and the morning Callum sent in his crew, Josephine had argued cases before the state Supreme Court. She had testified before a U.S. Senate subcommittee on housing discrimination. She had trained 2 generations of housing attorneys at the law school where she taught as an adjunct for 20 years. She had also 3 times successfully defended the Dunmore Heights Community Land Trust against attempts to acquire the land. Once by a private developer in 1998, once by a city redevelopment agency in 2007, and once by a consortium of investors in 2014 who had apparently also failed to read the title carefully. She had won all 3 times. She was 74 years old. She had reduced her caseload. She attended her grandchildren's school plays. She grew tomatoes in the community garden, plot 7, 3rd row from the gate, and she brought the harvest to the senior center 2 blocks over every August. She was, by any reasonable measure, retired, but her bar license was current. It had been current every single year since 1976. That detail, that quiet, unremarkable administrative fact, is the one Derek Callum's legal team never thought to check. And it is the detail that would make everything that came next possible. Derek Callum had been developing property in this city for 22 years. He had built strip malls, converted warehouses into loft apartments, and, in the last decade, pivoted toward what the industry called opportunity zone development, acquiring land in historically underinvested neighborhoods, building market-rate or mixed-use projects, and capturing the tax incentives that came with the federal designation. He was good at it. He had a portfolio worth north of $90 million. He had 3 active contracts with the city, infrastructure-adjacent development agreements worth a combined $18 million, and he had a reputation among city council members as someone who got things done. He had been watching the Clement Avenue lot for 2 years. In his analysis, and in the analysis his team prepared, the lot was categorized as city-adjacent vacant land, informally maintained by a neighborhood association. His researchers had found the neighborhood association's name. They had found the garden's social media presence, a Facebook page with 847 followers, photos of summer harvests, an announcement about a fall planting day. What they had not found, or had not looked for, was the land trust. This is a failure that real estate attorneys find almost inexplicable in hindsight. A title search, a standard, mandatory step in any legitimate property acquisition, would have surfaced the land trust covenant within minutes. The trust's name appears on the deed. It appears in the county recorder's office. It appears in the state's nonprofit registry. But Derek Callum's team had not conducted a title search on this parcel because, according to the permit application he filed, he was not acquiring the land. He was claiming it under a city ordinance that allowed developers to petition for emergency site clearance on blighted or hazardous vacant property, a provision designed for genuinely dangerous abandoned sites, not for functioning community gardens. He had obtained that permit, the city had issued it, and he had moved. What he had not done, what no one in his orbit had thought to do, was ask the simplest possible question. Does anyone already hold title to this land? And what does that title say? The answer was 37 years old, sitting in the county recorder's office, waiting. The crew arrived at 11:47 on a Tuesday night. Neighbors heard it first. The low diesel groan of machinery, the clang of metal, the particular sound of wood being split under pressure. Several residents came to their windows. A few came outside. One man, a retired postal worker named Clarence who had lived on Clement Avenue for 31 years, stood on his porch and watched a track loader push through the garden gate. He took a video on his phone. It is 2 minutes and 40 seconds long. In it, you can hear him say, quietly, to no one in particular, "They can't do this. That's our garden." By 3 in the morning, the raised beds were gone. The tool shed at the back, built by a neighborhood work party in 1994, stocked with donated equipment, a place where children had learned to plant seeds for 3 decades, was flattened. The mural wall was the last thing to come down. It had been painted in 1993 by a group of neighborhood teenagers, supervised by a local artist. It showed the history of Dunmore Heights in panels, the original families, the church, the civil rights marches of the 1960s, the garden itself. It had been repainted twice, maintained through every winter, photographed by every local journalist who ever did a story on the neighborhood. The track loader hit it at 4:17 in the morning. By sunrise, the lot was cleared. And Derek Callum had scheduled a press conference for 8 o'clock. He stood at a podium he had brought himself in front of the cleared lot in his pale blue shirt, and he said the word underutilized 4 times in 6 minutes. He talked about community investment and revitalization and bringing economic opportunity to neighborhoods that have been overlooked for too long. A reporter asked if the neighborhood had been notified. He said the permit process was the notification. He was smiling when he said it. Josephine Mercer's phone rang at 6:03 in the morning. It was Clarence, the retired postal worker. He had her number because she had given it to every block captain in Dunmore Heights 20 years ago, with instructions to call it if anything happened to the garden. He had never needed to use it before. She listened without interrupting. When he finished, she asked 2 questions. The first was, "Is anyone physically injured?" The second was, "Is the lot fully cleared?" The answers were no and yes. She said, "All right, I'll call you back." She did not panic. People who knew Josephine well would later say that this was the thing about her. She had a quality they struggled to name, something between stillness and precision that activated in inverse proportion to the urgency of a situation. The worse the news, the quieter she became. The quieter she became, the more dangerous she was to whoever had caused the problem. She opened her satchel. She pulled a file she had maintained for 37 years, updated annually, containing the land trust's incorporation documents, the deed, the covenant language, the board minutes, and the record of every previous legal challenge and its resolution. She also pulled her bar card. Then she made 3 calls. The first was to a former student of hers, now a partner at a civil litigation firm, who had clerked for the state Supreme Court and who owed Josephine Mercer, by his own repeated admission, his entire legal career. The second was to a city council member she had known for 16 years. The third was to a journalist at the city's largest daily newspaper who had covered housing issues for a decade and who had Josephine's number saved under "Call immediately if she calls you." It was 6:22 in the morning. Derek Callum's press conference was 98 minutes away. The press conference went exactly as Derek Callum had planned it, for the first 4 minutes. He had prepared remarks. He had renderings of the proposed development, a mixed-use building with ground-floor retail and 60 units of housing, 40% of which he described as affordable, though the income thresholds in the fine print defined affordable at 80% of area median income, which in this neighborhood meant most current residents would not qualify. He talked about jobs. He talked about investment. He used the phrase community benefits 7 times. Then a reporter asked about the land trust. The question came from the journalist Josephine had called at 6:22. She had done 40 minutes of research before arriving, including pulling the deed from the county recorder's online database, a search that took her 11 minutes, and confirming that the Dunmore Heights Community Land Trust held title to the parcel. She asked Derek Callum on camera whether his legal team had reviewed the land trust covenant before applying for the emergency clearance permit. He paused. It was a brief pause. 2, maybe 3 seconds, but it was the kind of pause that journalists recognize immediately, because it is the pause of someone who has just heard a word they were not prepared for. He said, "We followed the city's permit process in full. All appropriate due diligence was conducted." The reporter followed up. "Are you aware that the Dunmore Heights Community Land Trust holds title to that parcel, and that the trust's covenant prohibits any site alteration without board approval?" He said, "I'd have to refer you to our legal team for specifics." She said, "The trust chair, Josephine Mercer, filed an emergency injunction 40 minutes ago." The press conference ended shortly after that. Derek Callum walked to his car without answering further questions. His communications director, who had been standing to the left of the podium, was already on her phone. His attorney, reached later that morning, said the firm was reviewing the situation. Josephine Mercer, at that moment, was in her former student's law office, reviewing the injunction language for the second time, making 2 small edits in the margin with a blue pen. The injunction Josephine filed that afternoon was not complicated. It did not need to be. A community land trust covenant is one of the most legally durable instruments in American property law. When a land trust holds title to a parcel, that title is not a lease. It is not a license. It is not an informal arrangement that can be superseded by a city permit. It is ownership, recorded, covenanted, and binding on every subsequent party who touches the land, regardless of whether they checked. The legal principle at work is ancient. You cannot convey what you do not own, and you cannot alter what you do not control. The city's emergency clearance permit authorized work on land the city did not control. The permit was, on its face, void. The injunction requested 3 things. First, an immediate halt to any further work on the parcel. Second, a court order requiring the city to suspend the emergency clearance permit pending a title review. Third, a declaration that the demolition conducted overnight constituted an unlawful trespass on land trust property, and that the developer was liable for restoration costs. The judge who reviewed the filing granted the emergency halt order the same afternoon. It took her 22 minutes to review the documents and sign the order. The city's legal department, reached for comment, initially said the permit had been issued in good faith based on information available at the time. What that statement carefully did not say was that the information available at the time included a recorded deed in the county recorder's office that had been there since 1987, and that a title search, which the city's own permitting guidelines technically required for emergency clearance applications on parcels without a clear city ownership record, had not been conducted. That omission would matter. It would matter very much. But the story was not finished, not by a long way, because Josephine Mercer had not stopped at the injunction. The same afternoon she filed the injunction, Josephine Mercer sent a letter. It was addressed to all 9 members of the city council. It was 3 pages long. It was written in the precise, unadorned language of someone who had been writing legal correspondence for nearly 5 decades. No flourishes, no emotional appeals, just facts, arranged in an order that made their implications unavoidable. The letter documented the following: the land trust's incorporation and title history, the 3 previous legal challenges and their outcomes, the specific language of the emergency clearance permit ordinance and the title search requirement it contained, the timeline of the overnight demolition, and the names of the 3 city development contracts currently held by Derek Callum's firm, along with their combined value: $18,400,000. The letter did not say suspend those contracts. It did not need to. It said instead that the council might wish to consider whether the due diligence failures evident in this matter were consistent with the standards the city expected of its contracted partners, and that Josephine, as chair of the Dunmore Heights Community Land Trust, was formally requesting a council review of all 3 contracts pending the outcome of the court proceedings. She signed it with her full name, her bar number, and her title. Chair, Dunmore Heights Community Land Trust, established 1987. The council member she had called at 6:22 that morning, a woman who had represented a neighboring district for 16 years and who had, in her first campaign, been introduced to voters at a fundraiser organized by Josephine Mercer, brought the letter to the council's attention in an emergency session that afternoon. The session was not public, but 3 people who were in the room later described the same moment. When the council president read the line about the $18 million, the room went very quiet. Derek Callum did not know about the letter yet. He was still on calls with his attorney, trying to understand how a community garden had a land trust. Within 48 hours of Josephine's letter, the city council voted 7-2 to suspend Derek Callum's 3 pending contracts pending a formal review. The suspension was not a termination. That distinction mattered legally. A termination would have triggered contract dispute provisions that could have tied things up for years. A suspension pending review was cleaner. It was also, for a developer whose business model depended on city contracts and the relationships that produced them, considerably more damaging in the short term. Projects stall. Financing gets nervous. Partners start asking questions. But the suspension was only the beginning of what the review uncovered. When the city's inspector general opened the permit file for the Clement Avenue demolition, they found the title search gap immediately. That led, as these things do, to a broader look at the emergency clearance permit program. A program that, it turned out, had been used 14 times in the past 4 years, and that had, in 9 of those 14 cases, been applied to properties in majority Black or majority Latino neighborhoods. Of those 9 cases, 3 involved properties where community organizations had some form of documented claim. Not a land trust as durable as Josephine's, but lease agreements, recorded easements, and in one case, a city-approved community benefit agreement that the permit application had not mentioned. Josephine had not asked for this audit. She had asked for a review of the 3 contracts, but a letter from a 74-year-old civil rights attorney with a 37-year land trust and a same-day injunction has a way of making institutions look very carefully at themselves. The Inspector General's office opened a formal inquiry. The city's permitting department placed a temporary hold on all pending emergency clearance applications while the title search requirement was clarified. And a state housing advocacy organization, one Josephine had helped found in 1991, issued a public statement calling for a statewide audit of emergency clearance permit programs in every city with a similar ordinance. Derek Callum had cleared a garden. He had, in doing so, pulled a thread that was attached to an entire system. Derek Callum held a second press conference 4 days after the demolition. This one was different. He had a prepared statement and he read it without looking up. He said his firm deeply regretted the impact on the community. He said the permit had been obtained in good faith. He said his team was committed to working with community stakeholders on a path forward. He did not say the words land trust. He did not say Josephine Mercer. He did not say we were wrong. A reporter asked whether he would commit to restoring the garden. He said his team was evaluating options. Josephine Mercer did not attend the press conference. She did not issue a statement in response to it. She did not give interviews that week, though several journalists requested them. What she did was continue to prepare for the court hearing on the injunction, scheduled for the following week. She reviewed the restoration cost estimates that a landscape architect, volunteering her services, had prepared for the garden. She corresponded with the Land Trust's board members, all of whom had been notified, and all of whom had authorized her to proceed. She went to the cleared lot on Thursday evening, alone. Clarence, the retired postal worker, saw her from his porch and came down to stand beside her. They stood there for a while without talking, looking at the place where the garden had been. He said eventually, "You think we'll get it back?" She said, "We never lost it. The title didn't move." He didn't fully understand what that meant legally, but he understood what she meant. The land was still theirs. It had always been theirs. What was coming next was simply the process of making that visible to everyone who had forgotten to check. The court hearing on the injunction was scheduled for 9 o'clock on a Tuesday morning, exactly 10 days after the demolition. Derek Callum's legal team, now expanded to include a senior partner from a firm that specialized in municipal contract law, had filed a response arguing that the city's permit constituted a valid authorization for the work and that any title claims by the Land Trust were subject to a separate civil proceeding that should not delay the developer's right to proceed with his project. It was a reasonable legal argument. It was not a strong one, but it was the argument they had. Josephine arrived at 8:15 with her co-counsel, the former student, now a civil litigation partner, and a file box containing 37 years of land trust records. She was wearing her ivory blouse and her charcoal blazer. Her locks were pinned back with a tortoiseshell clip. She had a yellow legal pad and 3 blue pens. She had argued before this court before. Not this judge. This judge was younger than her by 20 years. But in this building, in rooms like this one, more times than she could count. The hearing lasted 2 hours and 40 minutes. The developer's attorney argued the permit. Josephine's co-counsel presented the title chain. Every recorded document from 1987 to the present, in order, demonstrating unbroken land trust ownership. Josephine herself addressed the court on one point: the specific language of the land trust covenant and its legal effect on third-party permit applications. She spoke for 11 minutes. She did not use notes. The judge asked 2 questions. Josephine answered both without hesitation. The judge then asked the developer's attorney whether his client had conducted a title search before applying for the emergency clearance permit. The attorney said, "The permit application process does not require." The judge said, "That wasn't my question." There was a pause. The attorney said, "A full title search was not completed prior to the permit application." The judge made a note. Then she made her ruling. The injunction was made permanent pending the full civil proceeding. The emergency clearance permit was voided. The developer was ordered to submit to a restoration assessment within 30 days, with costs to be determined in the civil case. The developer's 3 city contracts remained suspended. The restoration took 4 months. The civil case settled before trial. The terms were not made fully public, but the settlement included a full restoration fund sufficient to rebuild every raised bed, replace the tool shed, and commission a new mural, this one designed by a local artist who had grown up in Dunmore Heights and whose grandmother had been one of the original 1987 petitioners. The new mural included a panel that had not been in the original. It showed a woman in a charcoal blazer, wire-rimmed glasses low on her nose, holding a document. Nobody in the neighborhood needed to be told who it was. Derek Callum's 3 city contracts were eventually reinstated, 2 of them after a review process that took 8 months and resulted in new due diligence requirements for all city development permits, including a mandatory title search for any parcel where city ownership was not definitively established. The 3rd contract was not reinstated. The city declined to state why publicly, but the council member who had championed the review said simply that the city had reconsidered its priorities. His firm survived. It was smaller, quieter, and, by all accounts, considerably more careful about reading deeds. What happened to Derek Callum is not the most important part of this story. It is a part of it, the consequence, the reckoning, the moment when 37 years of careful legal architecture proved exactly as durable as Josephine Mercer had designed it to be. But it is not the center. The center is the garden. The center is a group of people in 1987 who understood that informal claims evaporate and that the only thing standing between their community and someone else's plans was a recorded deed and the legal knowledge to use it. The center is Josephine Mercer, who spent 37 years maintaining a file, renewing a bar license, and growing tomatoes in Plot 7. Not because she was waiting for a fight, but because she understood that the fight might come, and that when it did, the community deserved someone who was ready. She was ready. She had been ready since 1987. And when the machines came in the dark, and the mural came down, and a man stood at a podium and called it underutilized, the land trust held. The title held, the covenant held, because that is what you build when you know that someday someone will come for what is yours. You build something they cannot move. If this story is landing differently than you expected, if you came for the reckoning and found yourself thinking about what it means to build something that lasts, that's exactly what this channel is about. The like button is right there. If this hits something in you, you know what to do. And what's coming in the next section, the court hearing, and the one question the judge asked that ended the argument, that's the moment this whole story was building toward. Don't go anywhere. You've stayed through 10 sections of this story. That means something. The people who watch this channel to the end are the ones who understand that the truth doesn't always arrive loudly. Sometimes it arrives in the form of a 37-year-old document in a county recorder's office and a 74-year-old woman who never let her bar license lapse. If that's the kind of story you want more of, subscribe. This is what we do here, every single week. Justice that arrives quietly. Truth that speaks without shouting. The last 2 sections are the ones that matter most. Stay with it. Derek Callum thought he was clearing an empty lot. What he found out, in court, on the record, was that the most powerful document in that neighborhood was 37 years old, and the woman who wrote it was still standing. Thanks for watching. The end screen has more stories in the same world. Pick whichever story on the end screen calls to you. They're all waiting.